singular cases than in terms of systemic efficiency. Because if it didn't take 3 years, then it would have been able to hear 30 more cases in that time, but it couldn't because it took 3 years to dispose one case. So how do we work with civil procedure in such a situation is remains an interesting question over and over again. Do we dispense with the rigors of procedure in order to get efficient outcomes, or do we not dispense with the rigors of procedure? There are some aspects of civil procedure that has been up for much critical discussion in India, and I don't know if that's the case with Australia, but we can certainly talk about it. Things called adjournment. So when you don't go to court, do you get the day off, or is the matter dismissed, or are you given another date to come to court? Is there an excuse for not coming to court on a certain date? Your lawyer didn't make it to court, or the party didn't make it to court, so on and so forth. So there's all of that's happening. So adjournments are an interesting and an important aspect of this discussion, and they keep coming up, and several amendments have been made to the Code of Civil Procedure in India in order to reduce the number of adjournments that are given. There have been several amendments to the Code of Civil Procedure in India in order to enable faster timelines, so parties are held strictly to time, and said that if the plaintiff files a plaint, you're required to file your opposition plea by 30 days or 60 days or what have you. So things like that. And then there are a class of cases which are subject to what is called summary procedure, which means that some of this long drawn procedure that I was talking about is dispensed with in favor of a quick outcome, because the belief is that some cases are really open and shut. For example, if I gave you a check for $5,000 and I didn't pay up, then chances are that I did owe you $5,000, and which means that liability of $5,000 is going to be fastened on me without having to go through a rigorous procedural examination, because honestly I gave you a check. So things like that. Procedure also enables parties to not only receive judgment but also appeal against that judgment. So procedure governs how you move from one court to the next court. You have a system of appeals in Australia, I'm sure. I don't know what the courts are called, but you have a high court of something and a high court of something else. In India, we basically have at the lowest level a set of courts called civil courts, from where you have an appellate mechanism to what is called a district court, which means that a set of localities are captured in a district, and every district has a district court. And from that district, every province, or what we call state in India, has a high court, and ultimately from the high court you can appeal to the Supreme Court, which is located here in New Delhi. Even though India is a federal country, our system of courts is uniform, which means that there is a singular system of courts, although the other two branches of government, which means the legislature and the executive, is federal in nature by the constitution, but the system of judiciary is not federal, it's unified. All right. So we've spoken about the jurisdiction, and we've spoken about the methods in which a court hears a case. Let's finally talk a little bit about remedies. Excuse me. Remedies refer to the sorts of relief that you can get from a court. And remedies overlap between substantive laws and procedural laws. Think of the many remedies that you can seek when you go to court. The obvious remedy that you can seek is a remedy of compensation. I want money. But you can also seek other types of remedies. I'm certain that the Australian common law has similar remedies, like remedies, have you heard of specific performance, for example? So compelling somebody to do something. There are remedies which are injunctive in nature, which means that you prevent somebody from doing something, and so on and so forth. So variety of remedies are possible. The Code of Civil Procedure enables the granting of these remedies at interim stages of proceedings. So while the actual law of remedies is located in a diversity of other legislations, the Code of Civil Procedure itself deals with circumstances under which you can get a remedy but at an interim stage of trial. This is very important. Think of the following situation. Suppose I was building a house. I wanted to have a house built, and I started encroaching upon my neighbor's land while building that house. And the neighbor went to court and said that, look, he is encroaching upon my land. This is the limit of his land, and this is where my nose begins. So please don't encroach upon my land on construction. And I say, very well, I will answer this plea, and I know fully well that it's going to take 3 to 4 years for this plea to be answered, for the court to come to an outcome in the case. And so I will still build my house in the interim period, and I will, I might as well encroach upon your land. So at the end of 3 years, when the neighbor finally gets a remedy saying, oh, this construction was illegal, he would really not stand to benefit so much, because, either a part of my construction will have to be taken down, and that will be a laborious process. He's more and more likely to say, look, why don't we just settle this somehow? I let you live with this encroachment. Why don't you pay me a sum of such and such, and that will settle the matter. I might have been willing to pay that money anyway. And so in terms of outcomes, this is me winning the case, even though I actually lost the case. It's entirely possible that I managed to simply use the time period of the trial to my benefit and end up in a situation where I have compelled the opposite party to settle with me on my own terms. This doesn't seem like a fairly good outcome. Which means that there would have to be a system which prevents me from taking advantage thus. And what would be that system? Can anybody hazard a guess? What would be a system that prevents me from making this sort of a gain out of the litigation system? Because this seems like an immoral gain to me.
Would you get an injunction to preserve the status quo until the case is heard?
That is true. And this is called an interlocutory or an interim injunction. The Code of Civil Procedure is critical in granting this remedy of an interim or an interlocutory injunction. Now, the law in England, as well as I suppose the law in Australia and the law in India, is that a party during the time period of a trial can get from the court an interim protective order or an interlocutory injunction if the party is able to demonstrate to the court that there is a balance of convenience. The words used are the balance of convenience is in favor of such an order, which means that the relative inconvenience caused between the parties on the passing of an order is such that more inconvenience is going to be caused by not passing the order than by passing the order. This is complicated amount of use of words, but it is fairly simple. Think of a different example. Suppose I start manufacturing pens, and my pen manufacturing company is innovatively called Mont Blanc, which is anyway a very famous pen manufacturing company. Yeah. Not too many of us can afford a Mont Blanc pen, but if you can, then you should write with one. It feels like a dream on paper. But my company is also called Mont Blanc, but since I don't want to copy Mont Blanc, of course, I just spelt it differently. And so instead of Montblanc, as the French have it, I made it Mountblanc. So because Mont Blanc, after all, means white mountain, and Mount Blanc will also mean white mountain. And so I've made it, I've changed the spelling. And do you think Mont Blanc now has a claim against me? Yes, and that would be under the law of? That would be under the law of? Trademark? So this is a trademark infringement. It's fair enough. And so Mobla files a suit against me for trademark infringement and says, look, please direct the defendant to stop using this infringing trademark. And the court says, very well, I hear your plea. And I say, all right, very well, we'll hear the plea and here's my defense. And let's take good 3 years to decide on the outcome. In the interim period, I sold about 1 million Mont Blanc, the sort of the infringing Mont Blanc pens, and I, dented Mont Blanc's revenues severely, and I made a windfall gain out of it. So that doesn't seem like a just outcome. If Mont Blanc, on the other hand, was able to get an injunction from against me during the course of the trial, which prevented me from using this visibly infringing trademark pending the outcome of the case, then Mont Blanc would suffer no losses during the time period of the trial, which seems like a fair outcome. Except consider this. It may also be the case that my trademark wasn't really infringing, because let's not make up our minds. I gave you an example that seems like a fair case of infringement, but some cases are always in the margin, right? And there's a possibility that this is infringing, and there's also a possibility that this is not infringing. So if there's a possibility that this is not infringing, and at the end of 3 years the court decides, well, this is not infringement, then I can restart selling under the trademark, but I have lost 1.5 or 2 years in between, or 3 years in between, in which time I would have made sufficient gain. I have not been able to make that gain. It could be even, my losses could be so critical that I have had to shut down the company and not make pens at all. Which means that even though I won the case, I actually lost at the end of the day. So when granting this interim injunction, the court is actually faced with a very critical question. And remember, there are many things that are operating over here. So when the court was answering the question of interim injunction, it needed to bear in mind that the outcome could go either way. It is not appropriate for the court to make up their mind that the outcome is going to be this way or that, because that's exactly what procedural law doesn't let us do. Procedural law says that you must subject the matter through a rigorous trial in order to come to an outcome. And yet the court, unless it makes up its mind in some sense or the other, will not be able to deliver an effective injunction, and one party is likely to be prejudiced at the end of the day. And which is where that balance of convenience comes in, which means that you have to balance the relative inconvenience that would be caused to either party and come to an outcome. And this is, as is evident to you, is a fairly complicated and a very, very difficult equation to solve. But courts have ways of solving that equation. There are various doctrines that help them. There's plenty of precedent, and there's always ways in which that can be argued. But what we also realize, therefore, is that civil procedure plays an extremely important role in determining how much prejudice you're actually going to end up suffering at the end of the day. So let me go back to this example and tell you what is exactly going to happen. What is exactly going to happen is this. When Mont Blanc approaches the court and the court passes an interlocutory injunction, I know that whether I win or lose at the end of 3 years, I am going to lose generally. I am going to suffer the economic prejudice. So instead of actually going through with this trial for 3 years, what I am simply going to do is modify my brand name to the satisfaction of Mont Blanc, such that Mont Blanc withdraws its case, and I can manage after making a minor adjustment, say, in my trademark. So I'd make the adjustment. Now, on the other hand, if Mont Blanc did not get the injunction that Mont Blanc had asked for, Mont Blanc may either have to modify its own trademark a little bit to distinguish itself from me, or better still, Mont Blanc would have to pay me a lot of money to say, look, why don't you change your trademark, and I'm going to pay you sufficient amount of money to compensate you. Which seems like the right thing for me to do. Mont Blanc is such a rich and a big company. I managed to fleece it for all it's worth. So, civil procedure especially this question in civil procedure of interim remedies, ensures that the stakes at a negotiating table changes. The settlements that happen outside court are often believed, so many people believe that when commercial parties settle outside court, they are settling outside the law, but that's not really what it is. The code of civil procedure or the law of civil procedure and the way it designs interim remedies has a pervasive effect on the terms of the settlement. So how you do your commerce will ultimately depend on how good you are at, or how good your lawyer is at knowing the law of civil procedure. And so when so if any of you take up civil litigation practice, you will realize that understanding the code of civil procedure is very, very critical. Nonetheless, there continues to be a problem with delays in India. And delays are assumed in an economic context, although there is no real reason for this assumption. But it is assumed that delays affect high stakes matter much more than it affects a low stakes matter. And that's just a prejudice. There's no real reason to believe that, but most people believe it anyway. That if the matter involves $1 million, then delay should be less than if the matter involves $5,000. So, but if that is that, then that is that. In 2015, the law of civil procedure was therefore amended to create a specialized system of litigation, which is called the commercial court system, which provides for faster procedures to deal with matters that involve a commercial question of high value. And so some of the rigorous laws of civil procedure, rigorous rules of civil procedure that are applicable generally and have been applicable since 1908 have been modified considerably in these cases. All right. Now coming to the last thing that I'd want to talk about in civil procedure is the question of costs. Litigation is a costly affair. It costs money to go to court. It costs money to pay your lawyers. There's court fees. There's paper that has to be spent on. There's ink that has to be spilt. So a lot of money is involved in civil litigation. Many of the advanced litigation systems of the world ensure that when a party loses a dispute, she or he must pay the entire cost of the litigation to the other side. This has a robust reason behind it, which is that if you likely believe that you're going to lose the dispute, then you might as well not fight it out. Because the longer you fight a losing cause, the more you'll have to pay at the end of the day in terms of costs. The jurisprudence on costs in India is vastly different, and you must be attentive to the fact that this is a developing country and not a developed jurisdiction. People in developing countries experience wider economic inequalities. The income gap is far greater than in many other jurisdictions in the world, which means that if you were to subject an already poor person to a vast amount of costs because she lost a litigation, then it is likely that you have caused severe injustice just in terms of an economic distribution framework, because that would just be an unjust outcome. So, so the law of costs in India is vastly different. There is a belief, and there is a growing belief, that at least the law of costs, so far as commercial matters go, which is matters between big corporations go, the law should mirror, so far as possible, the law of advanced jurisdiction. So there is no reason to show sympathy for the rich, but in ordinary civil litigation, the law of costs is still fairly muted, which means that costs, even when awarded, are fairly small. And so a winning party in an ordinary civil litigation still has to bear her own costs at the end of the day, which means that if you got an award of 10 million at the end of the day, it is likely that you've already spent 2 million on litigation. But that's just that. And if you have regard to the economic context, then that's fair. Right. Now, the law of civil procedure, this system of civil litigation, as I told you, applies to the resolution of disputes under civil laws, the laws of contract and tort and, property and so on and so forth, before a set of courts. But Indian courts, especially what is called the higher judiciary, which means the High Court and the Supreme Court, also listen to a wide variety of matters which are of constitutional importance, and which involve the litigation of a constitutional right of an individual, most often against the state. To this sort of litigation, the rigorous rules of civil procedure are not applicable. So the higher judiciary evolves and applies its own procedures, subject only perhaps to the principles of natural justice, which means that you give each side a fair hearing and so on and so forth, and then you can adjudicate on outcomes without rigorous rules of evidence and so on and so forth. These are often necessary because constitutional rights must be protected in the here and the now, and it would be entirely counterproductive to have constitutional rights litigated over a long period of time. Taking cue from this system of litigation of constitutional rights, in the 1980s, a large number of progressive social activists started approaching the higher courts in India, which means the High Court and the Supreme Court of India, with a large number of progressive social causes, asking the courts to intervene in those matters. The social activists had no personal stake in these cases. So, for example, a river was being polluted because effluents were flowing into the river from factories, and somebody went to court and said, look, do something about this. The government is neglecting its duty to protect the constitutional right of citizens to a clean and healthy living environment, so why don't you intervene? Although I am not personally affected, a large number of people are personally affected. Or slum dwellers were being, slum dwellers meaning people who live in itinerant housing, housing that's not permanent, who, obviously have no permanent houses because of the conditions of squalor. And so they were being evicted. The city authorities, the municipal authorities were raising slums and saying, look, get out of here, get out of here. And so somebody approached the court saying, look, these people have nowhere to go. They have a right to live somewhere in the city, and they're clearly not able to afford housing, and you have made no provisions for affordable housing. So pass an order directing the city authorities to not raise these slums to ground. So a wide amount of social action litigation took root in India in the 1980s and has continued ever since. This is called public interest litigation. Public interest litigation is sort of the last nail in the coffin of procedure, because if procedure required that a party with a dispute comes to court and litigates that dispute, social action litigation said bye-bye to even that. Which means that anybody could come to court claiming to represent the grievance of a wider number of people who, maybe for reasons of their economic status, could not approach the court. And in terms of progressive advocacy, this was a remarkable innovation and hardly seen anywhere else in the world. Because everywhere else, if you have to approach the court, you must show what is called locus standi, which means the right to stand before the court. And yet, Indian courts diluted this very requirement. This is a fundamental requirement of procedure, and they diluted it, saying, very well, you can just come to us and we'll look into it. And this had excellent effects in the earlier days in terms of forcing the government's hand to think in terms of policy and saying that, look, if you're neglecting your duty to take care of your citizens in certain ways or the other, then the court will remind you of doing so and will remind you on the basis of an action brought by an interested individual. But of late, progressive writers, and this is why I want to highlight the word progressive writers, progressive writers have started criticizing this very mechanism. This is a very interesting book which was written in 2016 called Courting the People, in which this habit of the court in an attempt to reach out to people through the agency of socially active individuals has started producing counteractive effects. So, in the 1980s, a case, as I said, was brought on behalf of pavement dwellers, saying that these people can't be moved from the pavements because they really have nowhere else to go. You cannot sort of yank them off the pavements in which they've made their little small hutments, and if you throw them out, where will they go? Their right to life is at stake. And the court said, yeah, very good. The turn of the last decade, a case was brought to court saying that, look, an unauthorized living area, huts on the pavement, so to speak, pose a serious threat to sanitation in the area, right? And because the conditions in these settlements is far from sanitary, they become a breeding ground of disease, and therefore the other residents of the area who obviously have big houses are subject to a threat in terms of their health, and so their right to health is being affected, and this is therefore a social action litigation that calls upon the state to demolish that slum or to demolish the unauthorized settlers' colony. So you notice that what was the outcome between a period of 20 years is flipped. What may have been the tool in the hands of the marginalized can turn into a tool against the marginalized. And the reason for that is that you open the doors of the court to anybody to come and say, look, a large mass of people are being affected, this is a social action litigation. Because left to themselves, none of these people who lived in these big houses around the settling colony would have actually themselves come to court and asserted their rights. But one of them did on behalf of everybody else, and it became a social action litigation. Which then tells us that procedure is not just procedure, it is also extremely political. It is political procedure. Because the way you change procedure for the benefit of a community can then turn around and become Frankenstein and go against that very community. So at the end of the day, perhaps, there is some benefit to holding on to the rigorous rules of procedure, even if those rigorous rules of procedure have some inefficient outcomes. Which is why the study of procedure and the engagement with procedure is very important. And India is an example of experimenting with procedure. It has tight procedures at one end, it has very loose procedures at the other. Both of them have, to use the simple term, pros and cons. And a rigorous engagement with procedure is therefore very, very important. All right, so I will stop there. I've spoken quite enough, and if I speak any more, my throat will give way. And I will encourage any questions that you may have, whether from civil procedure. One thing I didn't talk about is criminal processes, but if you would like for me to say anything about that, then do feel free to ask. Or anything else that you would have to say and talk about, we can just while away the next 20 minutes chatting about that, and then we can say bye-bye. So, go ahead. Yeah, up to you all. Yeah.
You gave us an example of a procedure that took 3 years. Is that quite typical, or are there certain matters that would go beyond 3 years?
Yeah, to answer the question very briefly, yes, 3 years was a very conservative estimate. It would be much longer. I can tell you as a fun fact that when I joined litigation before I became an academic. I used to practice in law courts, and I practiced somewhere between 2011 and 2014. And one of the cases that I was representing in was commenced merely 100 years back. So one of the litigation that I was involved in was commenced somewhere in the 1914 or 1915. So it was a lot of fun.
And having said that it took so long, was there one particular process in the matter that was the key, the key thing that delayed it, or?
That's a great question, and I think that very often when people speak of systemic delays in courts, they always look at procedure. There must be this one problem with procedure that caused all of this. It is inconceivable that any rule of procedure would have delayed a matter for 100 years. No, that's just because people kept dying. Plaintiffs just kept dying one after the other, and their sons and daughters just continued the litigation. But when you're looking at a delay between 5 to 7 years, that's where you're looking at problems like adjournments, problems like repeated interim applications, and so on and so forth getting in the way. But otherwise, this sort of systemic delay doesn't happen because of procedure. There are some delays that are attributable entirely to procedures, but not all. Yeah.
In Australia, over the last few years, we've had a big increase in alternative dispute resolution. It's a lot of mediation and arbitration. Has India looked to move more that way in the civil area?
All right. Okay, so I'll just take a bunch of them and yeah, go ahead. I'm going to answer all of them together, so go ahead.
Oh, no, I was just curious. Have you ever done like a class action, and are they very common here in India, and how does that work?
Okay. Right. Okay, so your question was on alternative dispute resolution. So the system of arbitration, which is considered alternative dispute resolution, but for no particular reason, it's just taking that same thing outside a courtroom and just having people sit across the table and do the same thing over. Across the world, arbitration is considered as an alternative method of dispute resolution. That makes literally no sense. It's just that you don't have to wear a gown and go to court. You just come in suits to a fancy conference hall and eat snacks while you talk. But otherwise, of course, commercial disputes in India over the last 30 years have been largely subject to arbitral procedures. Contracts tend to always have an arbitration clause. We have had a lot of back and forth in terms of what the level of control that courts exercise over arbitration procedures. There's been a lot of back and forth on that law. But commercial disputes are largely driven by arbitral procedures, although arbitration awards can then be challenged in courts, and so that would result in delays. So far as other means of dispute resolution go, like negotiation and mediation, there has been a concerted attempt over the last decade to strengthen the institutions of negotiation and mediation. I think the problem is that everybody accepts that negotiation and mediation is a fantastic way of going ahead with commercial disputes, but not what everybody realizes is that negotiation and mediation is a taught subject at law schools across the world, and it's not a taught subject in Indian law schools, which means that we keep thinking of negotiation and mediation, but what we actually end up with is a adversarial encounter from across the table in which we are citing legal provisions at each other, which is exactly not the aim of a negotiation or a mediation process. So it's almost like a good process that has been slapped into a context where there's no appreciation for that process. Because the lawyerly community is so invested in litigation in India that it will take a lot of unlearning for negotiations and mediations to take grip in the same way as it has in other jurisdictions.
Because I don't know about in India, but we have a small claims court like VCAT. You don't get representation and things like that, but the idea is to make it quicker, especially for people with less means. Is there something equivalent like that in India?
So we have a consumer disputes resolution forum where in case you have a problem like your refrigerator stopped working and the company refused to come and give you services, then you can go there, and that's fairly quick. If the pecuniary value of your case is really small, but and in India that amount is really paltry, then there are specialized small causes courts where matters are supposed to happen very quickly. Doesn't necessarily translate into all of that, but yeah, I mean those have been in place for a while. But the gravitational pull of the main court system for civil litigation is still very high, so that's a systemic point more than anything else. Yeah. Class actions. So we don't have, so class actions are an interesting thing, right? Class actions refer to a civil case brought by one on behalf of many. We have a system of what is called representative suits in India, and so if there are 100 plaintiffs, one plaintiff can afford to represent 100 plaintiffs. It's a little different from a class action in the US, because in the class action in the US, it is one lawyer bringing a case on behalf of 100 plaintiffs who are not on the record. In India, it is one plaintiff representing 100 plaintiffs who are still otherwise on the record, but they don't have to come to court every day and so on and so forth. I haven't done class actions, but I have done a constitutional litigation in which I have represented people who are otherwise not before the court. So what I told you a social action litigation is, I've done one or two of those in the brief career that I spent in courts. Those were, I promise you, entirely for noble and good causes. I did not represent big landowners and things like that. So yeah, that's what I did. Yeah. All right. Anything else? Yes, go ahead.
Could you maybe take us just through the processes again? You started off with the record of the facts. I was wondering if at that stage there was to be a cause of action alleged, among a few other things. Discovery and inspection. I wondered if all of the evidence has to be adduced at that stage.
Right. So just to run through the processes really quickly. So the first stage of the process is a plaint filed by the plaintiff, which contains a record of the facts, and the cause of action must be evident from that plaint, because if the plaint does not disclose the cause of action, then the matter does not commence at all. In response to the cause of action, the defendant submits what is called a written statement. That means that the defendant is denying the cause of action, because if the defendant admits the cause of action, then the matter is over then and there, and the court can pronounce judgment on the basis of that written admission. Following which, there is discovery and inspection, which means that the documents that you wish to rely upon in trial must be adduced at this stage. It is not so much adduced to the court as it is given to the other party, so that the other party has an opportunity to know what are the documents that you wish to rely upon during the course of the trial. After that is done, the court takes the evidence, which means that the court looks at the documents that you have adduced, as well as hears any oral evidence that you wish to bring, including any witnesses that you may want to examine. If you bring a witness for examination, the other side has the right to cross-examine that witness, and so that's what happens. And finally, after all the evidence is done, you get a chance to now argue on the implication of the evidence as a legal matter. So whether a certain precedent supports you, or what the position of the law is. So you get to finally make a legal argument, so which then ties up all these things together to your outcome. So that's how the process.
And is the arguing of the record also called a hearing?
Yeah, that is called a hearing.
Okay, so the one thing is called a hearing, or is each visit called a hearing?
All right. So colloquially, every visit is called a hearing to the court. So every time the court takes a matter up, whether it is for looking at evidence, whether it is for examining a witness, all of that is called a hearing. The last stage is called the final hearing, when the arguments are adduced. Okay. Yes.
Just a quick question about locus standi. You said that it's been diluted in the existing house, so is it through the courts, or was it through legislation?
No, so it was diluted in the context of social action litigation, brought to the higher courts and done entirely by the courts. So the courts just decided to entertain it, and as you know, in any common law system, precedent creates law, and so precedent created that law. There is absolutely no legislative backing for social action litigation otherwise. So the dilution of locus standi is an entirely judicial sleight of hand. It was not there one day and it was there the next. So if that sort of helps, yeah. All right. If you have anything else, no. Fair enough. I think we've stretched ourselves to 1 hour of 20 minutes, which is, 80% efficiency, which is well done. Well done to all of you. And, see you around.